crime, the crime of the new conviction. Now, here the judge did not make any finding that Mr. Moon committed the new crime of conviction, but only found that he committed new criminal conduct generally. The judge did not find that he committed the new homicide, and in fact, he appeared to say affirmatively that he was not making such finding. He said that, in essence, he didn't have any clear idea of whether Mr. Moon committed the new homicide or whether he merely committed the new uncharged crime of drug dealing. Here, the evidence for saying that Mr. Moon committed the new conviction crime of homicide was weak at best, and in any event, the judge didn't make any finding that he did it. The testimony of the victim's girlfriend was, in essence, that Mr. Moon was simply present at the scene of the crime, that he did not actively participate in the robbery or the shooting. The defense proffered by Mr. Moon through his attorney, namely me, was that Mr. Moon was present because he was trying to put these two groups of people in touch with each other so that they could sell drugs to one another, and that he didn't have any expectation that they were going to start stealing from each other or shooting each other. The testimony from the alleged accomplices that was introduced only through hearsay by the detective did say that Mr. Moon was basically guilty of murder. However, the judge ultimately said he didn't put much weight on that. What the judge ultimately found was, all right, well, I have found it's very clear that Mr. Moon, he doesn't dispute that he's violated the terms of his probation by not reporting drug use, facilitating drug deals, and then he cited the definition of criminal responsibility. And ultimately the judge said, best case scenario, he aided them in dealing drugs, both sides, that's admitted. Worst case scenario, he aided them in the aggravated burglary, which he then pled guilty to. I find that the new criminal conduct has been proven by a preponderance of the evidence. I think that he was, based off the testimony of the first witness, namely the girlfriend, and just the basic facts and admissions of the defendant, namely the admissions that he was dealing drugs. I don't put a lot of weight on the statements of the co-defendants, namely the people who said he was committing murder. So ultimately, a judge, according to State versus Harkins, the Tennessee Supreme Court, a judge has to make a conscientious and intelligent judgment that the defendant is guilty of violating probation. Here the judge was waffling. He's talking about best case scenarios, he's innocent, worst case scenarios, he's guilty, and it just says he's guilty of criminal conduct without specifying that the criminal conduct was murder or homicide or burglary. And so that's not a conscientious and intelligent judgment. Therefore, it was improper to stack the VOP sentence consecutive to the new homicide conviction. As a sort of a lesser, arguably irrelevant issue, I've attacked the judge's introduction of the hearsay testimony of the accomplices. And the reason I say it's arguably irrelevant is because the judge ultimately seemed to say that he didn't believe them anyway. And as I've argued just now, he didn't make any finding, at least not any clear finding, that they were telling the truth or that Mr. Moon murdered anyone. And so it arguably doesn't really matter that that testimony was wrongly introduced. But if this court were to find otherwise and were to find that the judge did find Mr. Moon guilty of murder, then it would be error because the judge would have been relying in part on this unreliable hearsay.
Well, the judge didn't have to find that he was guilty of murder. You're losing me just a little bit. I mean, the judge clearly said, I find by a preponderance of the evidence these things, and yes, he may have said, well, you know, at best it was this or worst it was this, but at the end of the day, he said he found by a preponderance of the evidence that he violated the terms of his probation. That's all he has to do, isn't it?
That's all he has to do to revoke the probation, yes. But to stack it on top of a new conviction, he's got to find that by preponderance of the evidence that the new crime has been committed. And so we weren't disputing that he violated his probation in these other ways, namely that he didn't report, that he mainly that he didn't report, and then arguably that he facilitated a drug deal, although there wasn't any. That wasn't part of the revocation allegation anyway. But so the point is, we weren't disputing the revocation. We were mainly disputing that it be stacked on top of the new conviction. In order to stack it on top of the new conviction, he did need to make a finding that the new conviction was basically true and that it was valid.
Or that the new conduct had resulted in a conviction, basically.
That it was, yes, but what we're saying, and all the judge seemed to find, was that some new conduct occurred, namely he was present at the scene, whether it was to deal drugs or to rob and kill, and that he couldn't stack this VOP on top of the new conviction for robbing and killing without finding that he actually did rob and kill. And
You're focusing on the homicide, though. He was also convicted of aggravated burglary for the underlying conduct. So what about that?
well, I mean, all the same things would apply for I mean, I will say, first of all, the revocation warrant doesn't even mention burglary, but all the same arguments for the homicide would apply to the burglary too, because there just wasn't any allegation that he went inside the house to commit, against anyone's consent or, to commit an assault. There was just ultimately, our defense could well have been true, and the judge seemed to allow that it could be true, namely that he went in there with consent to facilitate a drug deal, and then his two friends just sort of went rogue. And so I would say that all the same arguments for why there was no proof of murder and no finding of murder would also apply to the burglary. And then finally, we've also raised this denial of a speedy trial. To start with, the Tennessee Supreme Court and this court, albeit both of them decades ago, found violations of the right to a speedy trial in nearly identical circumstances. In Allen versus State, you had someone who was on 4 years of probation, a revocation warrant was issued, and then there was 2.5 years without the government taking any action on it. Ultimately, the defendant was incarcerated then on a new charge, and the Tennessee Supreme Court held that there was a violation of the right to a speedy trial. There was a similar situation in State versus Wallace, where someone was on probation, but then a revocation warrant was issued. There was 26 months of no activity on the warrant, where the defendant was apparently lost in the probation system, and ultimately this court entered the same ruling, finding that there was a violation of the right to a speedy trial. And in that case, they focused especially on the loss, or at least potential loss, of concurrent time had the warrant been served in a timely fashion. Here we had, again, over 2.5 years of delay. That's well in excess of the 1 year that the Tennessee Supreme Court requires as sort of a cutoff period. The reason for the delay was a negligent prosecutor and an intentional and malicious sheriff. The sheriff had basically a policy of violating people's right to a speedy trial, of not serving warrants until cases were fully served, and the only way I was able to get around that was I ultimately did get in touch with the prosecutor, and he fixed the situation.
What in the record supports what you just said?
There was an affidavit from myself that was attached to the motion, and there was nothing to ever undercut that, and the judge, I think, basically made findings along these lines. He ultimately said that it was a negligent delay because he focused exclusively on the prosecutor's actions and didn't specifically...
Well, did he say it was a negligent delay or an intentional malicious delay?
He said it was a negligent delay because he focused only on the prosecutor, and I'm saying I agree the prosecutor's delay was negligent, but the sheriff's delay, which I think the judge did at least touch on, what he said he didn't understand why the warrant hadn't been served. Again, I talked about in my affidavit that I had tried to get it served, and that they had said they had a policy of not serving them until the sentences were fully served.
Who's they? What's the basis of fact for the affidavit?
The Coffee County, that I had, when I first learned about the warrant, which was I think after the guilty plea in January of 2023, I promptly contacted the Coffee County Sheriff's Office and tried to get them to go serve it, and they were refusing and said that they had a policy of not doing that.
Who was that? Is that reflected in the record in any way?
It's reflected in my declaration or affidavit that I talked to them and that they stated that.
I have a question too about the timing there in January of '23. Does the record reflect when precisely the defendant learned about the hold? The most precise timing I see in any of the briefs is it was around the time of the plea. Do we know if it was before or after? Does the record reflect that?
I don't think the record says it real clearly. Best my recollection, it was the morning of the plea, but I don't claim it was after the plea. I think it was shortly before the plea, whether it was that morning or some other time shortly. I think it was that morning.
Is that significant?
The reason I've said it was significant is because it could be significant depending on how we interpret and apply Rule of Criminal Procedure 32, and I was going to get to that in a second, but the state has basically said that the law, I'm arguing that among other things, Mr. Moon was prejudiced by the loss of concurrent time. Again, Wallace relied on that heavily. Here, and I'll get to your question in just a second, but the judge ultimately said that the loss of concurrent time didn't matter because we hadn't proven that the other county would have made their sentence concurrent even if Moon had gotten a speedy trial. And I'm saying that they did give him concurrent time, and if the state wants to say, well, if we had gotten a speedy trial here, they would have changed their policy and given him consecutive time there, that's not something I have to disprove. That's something the state should have to prove. They should have to prove, how can I prove that if we had gotten a speedy trial here, the prosecutor in the other county wouldn't have, hammered him even harder and pressed for consecutive time there? But anyway, ultimately the state is trying to say that consecutive versus concurrent time is irrelevant because Rule 32 of Criminal Procedure makes this case consecutive by law to the other county anyway. And if this one has to be consecutive, the state has said that Rule 32 makes the other one consecutive to this one anyway, and if the other one's consecutive to this one anyway, it doesn't make any difference whether this one was consecutive to that one, and therefore there was no prejudice. That's their argument. There are two reasons why their argument is wrong. The first reason is that even if their reading of the rule is correct, namely that the other one is consecutive to this one automatically, that just means I messed up because I didn't mention the Coffee County's probation in the other county's plea colloquy. And I didn't. Is
any of that in the record? What aspect of the Franklin County proceedings are in this record, if any?
I think we were just taking the DA's word for it that I didn't mention this Coffee County probation in the other county's plea colloquy. So the other plea colloquy is not in the record, but the state still argued that anyway. And
are those judgments in the record?
That's what I was going to ask. Is that Franklin County judgment in the record?
I honestly don't think that they are, but the state was nonetheless arguing these points, and I didn't, I guess heavily counter that. But what I'm going to say is, let's assume that's all true, and that I messed up by not mentioning that in the other county's plea colloquy or in the judgments. The reason I wouldn't have mentioned it is because, as I said in my affidavit, I didn't even know for sure that there was any pending probation until a day or two after the guilty plea. And so I
thought you said you thought you'd learned of the hold the day of the plea.
I learned of a hold, which I guess signified that there could be a pending probation violation, but I didn't actually learn for sure that there was a pending probation violation until I contacted
What else
them.
would a hold mean in that context?
Well, a hold is just sort of I wasn't seeing any piece of paper telling me there's a hold. All I've got is a hearsay from my client saying some guard has mentioned to him a hold, and so the point is I didn't
You see a hold in an associated county. You don't necessarily know what it pertains to. Is that what you're saying?
Yes, Your Honor. And so the point is I obviously suspected that there might be a probation violation once he mentioned a hold, but I didn't really know ultimately what was going on until I contacted the clerk's office, which was
but given the context and given your prior inquiries, wouldn't you have thought at that point, well, of course, that's exactly what it is?
No, and I think in my declaration, I basically just said I didn't know for sure what it was. But yes, I mean, I obviously suspected it could be that. But, you know, if I don't even learn about this until right before the plea or shortly before the plea, I don't even know that there is a hold for sure or a pending probation case until after the plea, how am I supposed to look into Rule 32 and research that and figure out that, you know, a probation sentence counts as a sentence to serve or a sentence not fully served? And so even if the state's reading of the rule is correct, which I conclude it wasn't, my error was caused by the prejudice of the delay of 2.5 years. But I will come back for rebuttal. Thank you all.
Thank you.
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honor, this is a pretty dense kind of factual case, so I'd just like to step back and tell you just the basics. I know you've read the record, but the briefs, but we have a Coffee County judgment comes down 2018. Got a violation, got another violation. On third violation, he's charged in Franklin County with first-degree murder and aggravated burglary. That probation violation warrant was never served. So when we get back to Coffee County in 2023, he's raising, and it's rightfully so, a speedy trial issue. And so what the trial court in Coffee County decided to do said, I'm going to create a legal fiction at the probation revocation hearing, and we're going to pretend like you did not plead guilty in Franklin County earlier this year. So he wanted the parties to prove by a preponderance of the evidence the new conduct that was in that probation violation warrant that said he committed first-degree murder and aggravated burglary. And so we have that put on at the hearing, and the victim's girlfriend testifies. Defendant came in, he wanted to do some drugs, wanted to get some drugs, and he said, I want to bring in my cousins, but instead of 2 cousins, 2 African-American men come in, and then the defendant leaves the room, and then the African-American men shoot, murder, and rob, burglarize the house and take the money that the victim had. And so at the conclusion of the probation violation hearing, the court clearly says, I find the new criminal conduct has been proven by a preponderance of the evidence. I think that was based off of the testimony of the first witness and just the basic facts and the admission of the defendant. So the trial court did make a finding that he violated the conditions of his probation. So now what happens is we go back into the real world, and we are in 4035-310 that says if a defendant commits a violation for which he is later convicted, the trial court in the original jurisdiction may run the sentences consecutively. And that's what the trial court did in this case. The reason we're talking about Rule 32, and it's mentioned in my brief, and Your Honor, you're right, nothing about the Franklin County judgment is in the record, except for just, there's no judgment in the appellate record at all. But we do have the parties arguing and the discussions with the trial court. So what we know from their argument is that that judgment is silent. And when a judgment is silent under Rule 32, when you have a new judgment and an unserved sentence, which is what this is, I think defense counsel believes a sentence of suspension of probation is not a sentence. It's a sentence. So when that new judgment is silent, they will automatically run consecutively. So that's why we have this court mentioning Rule 32. That's why I mentioned Rule 32. One way or the other, these sentences are going to run consecutively to each other. If you have any questions on the hearsay, I'm happy to answer those questions, but it was reliable and the witnesses were unavailable because they invoked their Fifth Amendment right to remain silent.
Can I ask you about the Rule 32 point that you just brought up?
Yes, Your Honor.
If, as the defendant's saying, he was not aware of the Coffee County hold, or he became aware around the time of the plea, how could he fulfill his duty under Rule 32 to inform the Franklin County judge, hey, I have this unserved sentence? You see where I'm headed?
Yes,
with
Your
that?
Honor.
Can you
What
elaborate
we
on
have in the record is that and I think it's at in volume 2, the motion for speedy trial hearing, I think we have counsel say, I was representing him on both on the Coffee County and the Franklin, and my client told me he might have a hold. Right there at that time, at the very beginning of his representation in Franklin County, defense counsel knew there was a probability, if not a fact, that he was on probation. And so, as he said and admitted, he made a mistake because he knew he was on probation. He didn't have any of the probation violation warrants, but that doesn't mean that he did not know that his client was on probation, and that's what activates Rule 32.
So you're saying whether there was a VOP pending or not, there was still the service of a sentence taking place in Coffee County that should have been brought to the attention of the Franklin County Trial Court?
Yes, absolutely.
Okay.
Yes. If there are no further questions, we ask that you affirm the judgment of the trial court. Thank you.
Thank you.
Your Honor, in reference to that last point, about whether I should have known that there was an ongoing probation condition, whether there was a pending VOP or not, that's simply not the case, because as I believe the state admits in their brief, if there hadn't been any revocation warrant issued, then the probation would have fully expired. And so, absent the VOP warrant, there would be no probation pending, whether we want to call that a sentence or not. I've said that probation is not actually a sentence, because by law, the probation is what suspends the sentence, and it's a condition by which a sentence is suspended. Rule 32, I just submit, in addition to before I had said that assuming the state's reading of Rule 32 was right, then my error was caused by the delay, and that's certainly true, but I submit the state's reading of Rule 32 is not right. Rule 32 specifically talks about prior sentences to serve or sentences not yet fully served. And if it's talking about a sentence to serve, by definition, that's not probation. And so probation is it's not a sentence, it's a condition by which sentence is suspended. If it's suspended, you're not serving it.
Well, what about a sentence not yet fully served, though?
Sentence not yet fully served.
A sentence not yet fully served would be like a sentence that you're, that's been revoked already. And so if it's been revoked, you haven't yet, it's a sentence.
You're saying it has to be an incarcerative sentence in order for the terms of Rule 32 to apply?
Yes, Your Honor.
Well, let me ask you this. There are a lot of interesting little aspects of this case, but I think when you boil down a lot of things here relating to the prejudice analysis, if the VOP had been timely dealt with, and let's say he had been revoked to serve, and then the sentencing court in Franklin County would have had the second shot at sentencing your client, then he would have been subject to permissive consecutive sentencing under Section 115, correct?
Correct, except it ultimately would have been basically the DA that decided it more so than the judge, since we resolved it by plea agreement.
Well, the DA in conjunction with whatever your client would agree with.
Right.
But let's say you couldn't reach an agreement and he was convicted and he went to a contested sentencing hearing, he would be subject to permissive consecutive sentencing, correct?
Correct. And
Isn't that exactly what happened here?
Well, that's what the judge, basically, my argument on that is that he wasn't subject to consecutive sentencing there, and I don't see how I could prove that wouldn't have happened, but I feel like it should be up to the state to prove that it would have happened, to prove that the DA there would have changed her mind and required it to be consecutive.
I get that aspect of your case. What I'm saying is, let's pretend that this had timely happened and that he had been revoked in Coffee County before the Franklin County charges were resolved, which is what you're saying should have happened.
Correct.
And had the Franklin County case then gone to a sentencing hearing, he would have been subject to permissive consecutive sentences under Section 115, I think it's B6 because he committed those offenses while on probation for another offense.
And that is true. I don't dispute that. I'm just saying, I don't think that that's likely. The state hasn't proven it's likely. Ultimately, let me just close by saying, under United States versus Doggett, on some level, you're not even required to prove prejudice, and on some level, when the delay is lengthy, like it was here, prejudice can essentially be presumed. And I would just submit that principle should weigh in our favor, and we shouldn't have to conclusively prove that counterfactual idea. We would ask that the judgment be reversed unless there are any further questions.
Thank you, counsel.
Thank you. Call the next case, please.